here on Brass Tacks. Karnataka, of course, very tightly poised between the Congress and the BJP, and whether the JDS will play spoil sport or not. But the other big story today is coming in from Bihar, where the Nitish Kumar government is facing massive backlash for its decision to tweak prison rules, allowing the release of gangster-turned-politician Anand Mohan Singh, who faces life in prison for the murder of a Dalit IAS officer in 1994.
Anand Mohan Singh, the only former member of parliament to be convicted for murder and sentenced to death, is all set to walk free. All thanks to the Bihar government tweaking its prison rules. Anand Mohan Singh was convicted for provoking a mob and killing then Gopalganj district magistrate G. Krishnaiah in 1994. Earlier this month, the Bihar government had removed the clause which had forbidden the remission of jail term for those convicted of murdering a public servant on duty. This led to the release of 27 prisoners, including Anand Mohan Singh.
जो क्रिमिनल होगा उसको अटल जी क्यों जो है सो साथ बिठाएंगे, लालू जी क्यों साथ बिठाएंगे, नीतीश जी क्यों साथ बिठाएंगे, मोदी जी क्यों साथ बिठाएंगे? समझौता करने आए, समझौता हुआ, हम 7 चुनाव लड़े, 74 आंदोलन की उपज है हम लोग। जेपी आंदोलन से हम स्टार्ट हुए 17 साल से। फ्रीडम फाइटर परिवार है मेरा। ये क्रिमिनल कर सकता है क्या?
G. Krishnaiah's daughter Padma was 4 years old when her father was killed. 29 years later, she says she has been let down by the Bihar government.
Whatever decision the government has taken is kind of like very unfair to us, to the family, and also to the entire nation. That's what I personally feel. This is something that's definitely not expected.
The BJP accused the Nitish Kumar government of taking arbitrary decisions.
See, it is not the question of release of Anand Mohan. Along with Anand Mohan, 27 dreaded criminals who were sent to jail because of murder of the public servant. The decision of the Bihar government is unconstitutional, it is arbitrary, it is unnecessary.
Adding fuel to fire, Bihar Chief Minister Nitish Kumar and his deputy Tejasvi Yadav attended the engagement of Anand Mohan Singh's son, who himself is an RJD MLA.
डॉक्टर भीमराव अंबेडकर द्वारा बनाए गए समानता का सिद्धांत, इक्वलिटी का, जिसमें कि हर व्यक्ति को कानून में अपना पक्ष रखने का अधिकार है। सवाल किसी जाति और समूह का नहीं है।
नीतीश जी ने भी कंफर्म किया था कि इस मामले में मैंने आनंद मोहन निर्दोष हैं। उसके बावजूद 14 साल रहे वो, पर जो सवाल उठाया जा रहा है, ये सवाल दुर्भाग्यपूर्ण है।
So is the Bihar government putting politics above justice?
All right, we're getting a piece of breaking news in this connection. The Central IAS Association has now released a statement expressing dismay over the Bihar government's decision to release Anand Mohan Singh. The IAS Association calls it tantamount to denial of justice and undermining public order. The body has urged the Nitish Kumar government to reconsider its decision. It has, of course, led to a huge political backlash as well. People are questioning the need to change the jail and remission rules and the parole rules to enable the early release of Anand Mohan, as well as 20-odd other criminals who are serving life sentences. Let me now open this up to our guests who are joining us. Aman Sinha of the BJP, senior lawyer, will be joining us. Dr. Sunil Singh, JDU spokesperson. Naval Kishore, RJD spokesperson, also joining us. Dr. Sunil Singh, what explanation is there? This is a man who directly gave orders to kill a sitting district magistrate, a Dalit district magistrate. There were 10 witnesses who testified against him in court. The trial court, in fact, sentenced him to death. It's later that the High Court then curtailed that to life, and that was upheld by the Supreme Court. Why are you in such a hurry to give him early remission?
We are not in a hurry. Actually, Anand Mohan ji has served his 14-year sentence, and because of amendment in the jail manual which is being needed from time to time, he is being released because his behavior in the jail was good. He was a good. So he was being released. The amendment in the jail manual led to the release of 27 other people belonging to, most of them are belonging to even Muslim, Hindu, forward, OBC, MBC, Dalits, and everybody. So there is no allegation proves about the caste bias. So this thing about the jail manual amendment. So jail manual had difference for a public servant and the common man, and the right to equality that we equated any common man with the public servant, and that clause with special treatment.
But sir, the fact is it was not just any common man. The fact is this gentleman asked to shoot at a sitting district magistrate, a Dalit district magistrate, and also, I mean, a representative of the state at the end of the day. You cannot just arbitrarily say that, you know, we're removing the distinction between a common person and that of a government servant. You are shooting, giving orders, and there are 10 people who have testified to this in court, giving orders to kill a representative of the state who is in front of you.
No, but then what he did, he got the life imprisonment and he served for more than 14 years of sentence. He was punished accordingly as per law. And as per law, like there was a special provision for the government servant. I think I'm a doctor. I think anybody needs that protection. So for the right of equality, that the distinction between the common man and a public servant was just lifted.
Naval Kishore is also joining us. Naval Kishore, everybody in Bihar knows
time to time.
Mr. Anand Mohan Singh. Not just this case, there are numerous other cases against him. He's known as a bahubali. His wife, lovely Anand, also contested and has been MLA multiple times. She also has multiple cases, not small cases, very, very senior, very, very serious charges, dacoity, kidnapping, murder, etc. against this entire family. And the Chief Minister and Deputy Chief Minister are going for a wedding, an engagement in that family. They are side by side with this criminal who is facing a life term in jail, has come out on parole, and kande pe kande mila rahe ho.
I disagree.
Naval Kishore, thank you. Naval Kishore, thank you. Naval Kishore, please, thank you. Thank you. Yeah, Naval Kishore.
Yeah, you know, the wedding about which you are talking or raising a question, it is wedding of a person who is part of a political party. He is MLA from a party, and going to a marriage ceremony is crime. To what extent? How do you conclude that is a crime not to participate in a marriage ceremony?
He is standing. The Chief Minister, Deputy Chief Minister are standing next to a convicted criminal who is serving a life term. वो हाथ से हाथ मिला रहे हैं, कंधे पे कंधे डाल रहे हैं, मतलब it's like उनके दोस्त हैं.
नहीं, लेकिन वो सजा भुगत चुके हैं और बाहर आए हैं.
नहीं, ये भुगत चुके, ये नहीं भुगत नहीं चुके हैं. नहीं, भुगत नहीं चुके हैं. लाइफ टर्म दिया गया है उनको. लाइफ टर्म फॉर हीनस क्राइम्स मींस लाइफ. ये 14 साल नहीं होता. रेप, मर्डर जैसे हीनस क्राइम होते हैं, उसके लिए लाइफ टर्म इज लाइफ. ये तो सुप्रीम कोर्ट ने भी क्लैरिफाई कर दिया है.
नहीं, बिल्किस बानो केस में आपका क्या ख्याल है?
नहीं,
माया कुंडानी केस में आपका
बिल्कुल उनके केस में रेमिशन नहीं करना चाहिए था. 100%.
तो यहाँ पे जो रेमिशन हुआ है वो रेमिशन कमीशन है, और जो ग्राउंड दिया गया है उसमें कि द लॉ हैज टू बी इक्वली अप्लाई फॉर एवरीवन, एंड जिस क्राइम के लिए उनको सजा जितनी मिलनी थी वो मिल चुकी है और काट चुके हैं, और वो कमीशन ने डिसीजन लिया है. आप केवल एक व्यक्ति पे, एक पार्टी पे, एक सरकार पे इसी तरह का क्वेश्चन लाके और उन चीजों
नहीं वो ये सवाल तो जायज है ना नवल किशोर साहब, ये सवाल तो जायज है. इतने हार्ड एंड क्रिमिनल के लिए, और बाकी 25-30 लोग भी हैं जो हार्ड एंड क्रिमिनल्स हैं, उनको रेमिशन देने के लिए जेल मैनुअल की अमेंडमेंट करने की क्या नौबत पड़ी जेडीयू सरकार को?
देखिए, जेल मैनुअल का अगर कोई उसमें चेंजेस लाया गया है, इट इज बेस्ड ऑन द केस, इट इज नॉट बेस्ड ऑन व्हिच पर्सन इज गोइंग टू बी रिलीज. आपका कहना है कि पहले सर्वे करवाया गया कि इसका फायदा किनको मिलेगा, उसके बाद परिवर्तन किया गया. कितना इस तरह का विचार कहां से लाते हैं?
नहीं, तो आनंद मोहन के लिए नई अमेंड किया गया, ये जेल अमेंडमेंट जो किया गया है.
नहीं, आपको ये किसने और कैसे आपको ये पता चला कि किसी व्यक्ति को ध्यान में रख के किसी कानून में परिवर्तन लाया गया?
मेरे सवाल का जवाब तो दे ही नहीं रहे हैं आप. जेल मैनुअल, जेल रूल्स को अमेंड करने की क्या जरूरत पड़ी?
नहीं,
ये जो 27 लोग जो रिलीज हुए हैं, सबों को मतलब कोर्ट ने ही दोषी करार पाया है ना.
बिल्कुल करार पाया है और जो प्रोसेस है रेमिशन का उसको फॉलो किया गया है और उसके आधार पे दिया गया है।
नहीं, प्रोसेस को आपने बदला, प्रोसेस को आपने बदला और उसके बाद आपने रेमिशन दिया है।
प्रोसेस को जो बदला उसका एक आधार था, उस आधार पे बदला, उस आधार पे बदला गया और बदले गए कानून के तहत जो लोग भी उसके एम्बिट में आते थे उनको रिलीज किया गया।
Aman Sinha is joining us. Aman Sinha, both Sunil Singh of the JDU and Naval Kishore of the RJD are saying the same thing, that if you commit a murder of an ordinary citizen, life term is for 14 years and you are eligible to remission after 14 years provided there is good behavior. On the other hand, if you are accused of murder of a government servant, that is for 20 years. It should be the same whether it is a common citizen or a government servant who is the victim.
Zaka, this was a gruesome murder and lynching of the district magistrate of Gopalganj, and the convicts were handed out death penalty by the trial court as well as the High Court. Later on, Supreme Court commuted it to life imprisonment. Now, let me say that what has been done here is an absolute blatant violation of the CRPC and of the remission rules. Now, the gentleman must, stay quiet for some time. Everybody has heard him. Now, other perspective also needs to come forward. Now, this is in blatant violation to provisions of CRPC. Section 432 of the CRPC mandates that an application has to be moved before the competent court, the trial court, and the trial court has to permit for such a remission, then only a remission can take place. Secondly, Zaka, this was a gruesome murder of an All India Services officer. Section 435 of the CRPC mandates that in all such cases, the consent of the union government is a mandatory requirement. It has to be obtained, which has obviously not been done. Therefore, what has been done is absolutely illegal and against the provisions of law, against CRPC. Not only that, Zaka, I can tell you that there is a remission policy of the union government, and this what has been done here is also in disregard and violation to the national remission policy, because that stipulates that somebody who has been already convicted for death sentence and his sentence is commuted to life, they cannot be considered for remission. Therefore, on all accounts, this is a complete violation and disregard of the provisions of CRPC and the remission policy. Not only that, Zaka, what has been done here is something really astounding, because the rules, the jail remission rules, they have been changed specifically, and we find that the Chief Minister of that particular state is attending the party of that convict, and simultaneously the jail revision rules are being changed. Can it get more blatant than this?
Okay, so Dr. Sunil Singh, answer both of these points that Aman Sinha has raised.
Public of Bihar, will they have any confidence?
Number one, he's saying that this is... One second, Amanji, one second. Let me ask Dr. Sunil Singh. Number one, he is saying that you have to move an application in the trial court. It's the trial court that has to give the go-ahead for the remission. That has not happened in this case. And two, since the victim was a IAS officer, a Central Government Services officer, then a consent has to be obtained from the central government as well. That has also not been done. Please respond, Dr. Sunil Singh.
Yeah, first of all, he said that he was convicted to death from the High Court. No, High Court converted the death sentence to a life imprisonment, which Supreme Court upheld it. And second thing, about the thing is saying that if he is an IAS officer of central cadre, the center consent has to be taken. As per my knowledge, he might be a senior lawyer, but I beg to differ. There is no provision as such. It is only a civil servant, and that clause was deleted because time to time
please, Sunil Singh ji, you are an educated, enlightened man. Why do you not read section 435 of CRPC and then come and debate with me? Please go back and read section 435 of CRPC. And have you read it? What does section 435 of CRPC mandate? So without knowing the provision, do not pass your sweeping judgment.
Do you mean to say... do you mean to say that if IAS officer is killed, then the rule is that central government consent is to be taken? As per my knowledge, this is not the case. since you're a senior
I'm
lawyer,
quoting you the provision. Where do you derive this knowledge from? Sunil Singh ji, what is the source of your knowledge? I am quoting the relevant provision of CRPC. Please go and take out on Google right now and read section 435 of CRPC.
My source of knowledge.
What is your source? Please disclose to Zaka and all the people who are listening, all the educated viewers of News 18. Please disclose to them what is this reliable source that you are having.
Right now, I don't.
What do you mean by proper time? You do not know what your source is, and I am quoting you the provision of law, specifically section 435 of CRPC.
Bihar government.
Oh, you know you are not the Constitution of India. Please, Dr. Sunil Singh ji,
look,
you are a doctor. You should not argue like this,
Amanji,
devoid of any facts and law.
10 seconds.
Sir, one second.
10 seconds.
Okay, finish your 10 seconds.
Amanji,
okay,
10 seconds.
Yeah.
10 seconds, Amanji. Amanji, 10 seconds.
I am hearing.
What is your opinion about the release of Bilkis Bano, where the remission board has a BJP leader on board? And then what is your opinion about that? Where there's no CRPC there, there's no IPC there.
Now,
what is it?
Now, although that is not the subject matter of discussion, but let me tell you, Zaka, that was not a case where any remission rules were amended or bent. It was done in consonance and directions to the orders of the Supreme Court, and thereafter it was considered under the existing rules. And here, the rules have been blatantly changed. Not only have they been changed, they have been changed in contravention to the provisions of CRPC, to the union remission policy, and Mr. Sunil Singh, instead of responding as to what is this great source of information that he's having,
I want our viewers to please pay attention. One second, Sunil Singh ji and Aman Sinha ji. I have section 435 of the CRPC open in front of me. It says, and I quote, state government to act after consultation with central government in certain cases where 1. Powers conferred by sections 432 and 433 upon the state government to remit or commute a sentence in any case where the sentence is for an offence which involved the misappropriation or destruction or damage of property belonging to central government. That is section B. Section A is which was investigated by any agency empowered to make investigation into any offence under any central act other than this code. And section C is which was committed by a person in the service of the central government while acting or purporting to act in discharge of his official duty shall not be exercised by the state government except after consultation with the central government. This is section 435.
Absolutely, Zaka, you've read the correct provision.
Zaka, this is not the case. Zaka, this is not the case. What he was saying that if the victim is a central IAS officer, the central government consent is to be taken. CRPC, the thing which you have read, Zaka, does not mention this.
Each and every, it is all India services, central government officers are there. In fact, even if a central government property is damaged, then also...
Okay.
Then also
I am completely out of time. I'm also getting a piece of breaking news that's coming in, which I need to go to urgently. So thank you very much to all our guests on the Bihar debate. But this piece of breaking news coming in from Karnataka, this is relating to the Karnataka, the 4% Muslim quota. The Karnataka government has now opposed the plea in the Supreme Court challenging the scrapping of the 4% reservation. The Karnataka state government says the plea is not maintainable as the petitioners have directly knocked on the doors of the Supreme Court. The government says the government order was passed after subsequent orders of the High Court and the matter is still pending before the High Court. Karnataka government says reservation on the basis of religion is unconstitutional. This is the response of the Karnataka government. They were supposed to file this and the next hearing was supposed to happen on the 9th of May. Let me go across to Ananya, who has more details on this. So the Karnataka government saying that asking the Supreme Court to dismiss this matter, saying it's not maintainable because they have not approached the right judicial forum.
Well, definitely, Zaka, the Karnataka government has raised various points when it comes to opposing this petition that was filed against the scrapping of 4% OBC quota for Muslims in the state of Karnataka. And now a very, very big and important pointer that the Karnataka government has highlighted apart from the maintainability of this whole case is that the reservation on the basis of religion is unconstitutional. And I read that and quote that particular affidavit that has been filed by the Karnataka government through the Solicitor General of India and the Karnataka AG, Mr. Prabhuling Navadgi, is that it is humbly submitted that first text to be determined in whether the state can provide a reservation in public employment and educational institutions solely based on religion. The aim of reservation as envisaged in the Constitution is to promote social justice for providing affirmative action, basically meaning that, the reservation on the basis of religion is something that cannot be permitted by the Constitution of India and could not be granted. And that's the reason why, in fact, this 4% reservation for Muslim community has been scrapped. Apart from that, what has also been stated by the Karnataka government is that the plea is not maintainable in nature because the right forum, which is at this point of time, is the Karnataka High Court, has not been approached of, and already certain petitions are pending before the Karnataka High Court in this particular case.
Okay, Ananya, we'll leave it at that. We'll see how this further plays out. 9th of May is when the next hearing will happen in this case. Meanwhile,